Welcome back to the channel, where today's courtroom showdown is packed with twists, high stakes, and some jaw-dropping decisions that you won't believe. Right from the start, we've got defendants facing everything from marijuana possession, all the way up to double murder charges. But it doesn't stop their prior convictions, rejected plea deals, and a massive 45-year offer from the state are all on the table. And here's the kicker. Instead of cutting a deal, one defendant decides to gamble it all and head straight to trial. Why reject decades behind bars for a chance at freedom or a life sentence? Stick with me, because over the next few minutes, we'll break down exactly what's happening, why the judge reacts the way they do, and how each decision could shape these defendants' futures forever. Trust me, you're not going to want to miss this one.
Second, Mr. Batiste, in cause number 24, DCCR 0407, charged with the state jail felony offense of possession of marijuana from October 14th of 2023. And what that means in that case is if you go to trial and you're found guilty, the range of punishment would be between 6 months and up to 2 years in prison. Do you understand? So again, in 24 DCCR 0917 and 0918, you're charged in each of those cases with the first-degree felony offense of murder from January 10th of 2024. The indictment in each of those cases alleges that you were previously convicted of robbery, a second-degree felony, October 26th of 2018, and also unlawful possession of a firearm by a felon on that same date. And what that means in those two cases is that if you go to trial and you're found guilty, the range of punishment would be enhanced. The minimum punishment would be 15 years in prison up to 99 years or life in prison. Do you understand?
So, let's pause here for a second. What the judge is really saying is, this defendant has 2 murder charges, plus prior convictions that boost his punishment range. Normally, a first-degree felony starts at 5 years, but because of those priors, the minimum here jumps to 15 years, minimum, and the maximum, a staggering life in prison. Think about that. The prosecution sweetened the pot with a plea deal. 45 years in prison if he agrees right now. It sounds brutal, but compared to a possible life sentence, that's actually a bargaining chip. Here's the question for you: if you were in his shoes, would you roll the dice at trial or take the deal? Drop your answer in the comments.
And then in all 3 of those cases, I have here on the computer some documents, the plea bargain rejections that you've signed with Mr. Gertz, that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. And it looks like the agreement would be for a 45-year term in the institutional division of the Texas Department of Corrections in the 2 murder cases, and I guess a 2-year term in that state jail felony that would run concurrently. All of them run at the same time. Do you understand the possible consequences if you go to trial and what your options are if you wanted to enter pleas of guilty? And do you want to reject those offers and have all of your cases set for trial? Okay, we'll get those cases set for trial. Obviously, if there are any pre-trial issues or legal things that we need to take care of prior to.
Sorry, give me just 2 seconds, Judge. Sorry, just to clarify, he was concerned because you said both of the priors were on the same date, and I said that was the date he was sentenced, not the date of the allegations.
Okay.
I was just clarifying that.
Okay, the convictions were from the same date.
And I was clarifying too that it's better that if it were
True.
separate days.
Right. Okay, so you want to reject those offers and have all of your cases set for trial, is that correct? Okay, then we'll get it set on the trial docket. Obviously, if
This moment right here is pure courtroom drama. The defendant just rejected the plea offers, meaning his fate is officially heading to trial. That's a bold, some might say reckless, move. Remember, prosecutors almost always offer less time than a jury would hand down, and if the state consolidates the 2 murder cases, as they just confirmed they plan to do, that's double the evidence and double the pressure in one trial. If the jury finds him guilty, that 45-year deal he just walked away from might start looking like a golden ticket. So what do you think? Is this confidence or straight-up denial of reality?
there are any legal issues that we need to take care of ahead of time, get whatever you need to filed so that we can take those up prior to any trial date. That way there's no worries when we get to a trial of going forward or not.
And
All right.
Judge, I don't know if Mr. Coleman has decided on behalf of the state if he plans to try both of the murder cases together. The marijuana is a totally separate incident, and whatever happens with that is what's going to happen.
I don't think that's the concern.
But I just want to
It's stated to file if we haven't already, a motion to consolidate these 2 cases.
Okay, you've already filed it.
Okay. Good.
Okay.
So we would anticipate trying both of them at the same time.
Perfect. Okay, sounds
Okay.
good then.
Thank you, Judge.
All right, you may go back with the bailiff.
Thank you, Judge.
Thank you. Good morning. Are you Tyron Henderson? And Mr. Henderson is on probation in 3 cases. In cause number 23 DCCR 0899, on probation for theft of property. In cause number 21-38934, on probation for evading arrest or detention with the use of a vehicle. And then in cause number 22-39131, on probation for unauthorized use of a vehicle. There have been motions to revoke filed in all 3 of these cases. Mr. Rennick has filed motions asking that I set bonds. Okay, so the theft of property is a straight probation. These other 2 are both deferreds. So just by the nature of looking at the dates, without getting too far into this, it appears that he was on probation for the evading and the unauthorized use, and then received another probation while he was on those for the theft of property. Is that correct?
That's correct.
And those other ones were continued
Yes, that's right.
after that violation. Okay. And there are no bonds set at this time. Mr. Smith, I'll get to you, Mr. Rennick, real quick, but what is the state's position on bonds?
The only concern I have, Judge, is the fact that he is on probation and committed a new felony offense. The fact that he's on probation, got deferred, has committed a new offense.
So in those motions, the allegations are 1, a new arrest for evading arrest or detention with a vehicle, an arrest for reckless driving, both of those from March 23rd of 2025, failure to provide verification of community service, out past curfew at 3:35 a.m., behind in his fees.
Now, let's break this down, because the bond decision here is critical. The defense argued for giving Henderson another chance, but the judge shut that door fast. Why? Because this wasn't a one-time slip-up. He was already on probation, already had opportunities to prove himself, and then got arrested again for the exact same thing, evading arrest with a vehicle. Add in reckless driving, curfew violations, and unpaid restitution, and you've got a perfect storm of broken trust. Judges take public safety seriously, and here, the risk was just too high. Honestly, can you blame the judge for saying no bond? Or do you think everyone deserves one last chance? Let me know your take.
And restitution. All right, do you want to call your client?
Judge, I don't want him to justify.
Okay.
About the thing. It's just basically our position is with this is that he has a hunch structure. He realizes he's messed up. He realizes he has established his probation. We're just really asking for what we set on. He doesn't want to show the court that he can comply with probation, get his classes done, all that stuff. He has 3 clients.
I'm not worried about classes or hours. I'm worried about the fact that you're still getting arrested for the same thing that you're on probation for. And you've already been put on probation and given an opportunity. You violated the law. You got another opportunity, and I continued you, and now there's some more violations. Based on those, and I'm taking judicial notice of the court's file, includes the motions, the administrative hearings. At this time, I feel that it is, especially with the nature of the offense alleged and what he's on probation for, with an evading with a vehicle, which is, it's dangerous. You could hurt somebody, you could kill somebody, you have officers out there. Anyway, I'm going to find that it is in the best interest of the community that there be no bonds in any of your cases. We will set these for whatever y'all want to on an announcement. If he's going to plead not true, we can have a hearing first on the motions and then move forward on the trial later if that's the...
Judge, with that ruling, what I'm going to do is try to Mr. Smith this week and see if there's something we can do to work this out quickly. So
Okay.
just get something figured out as quickly as we can.
Okay, sounds good. We'll do a normal reset at this time. If something happens prior to that, just let me know. We can always move it up. You can go back with the bailiff. All right, sir, are you Lentavius Strickland? And Mr. Strickland, you were previously in court, entered pleas of guilty to evading arrest or detention with the use of a motor vehicle, as well as unauthorized use of a motor vehicle. I've received the pre-sentence report and reviewed that. Has everyone had an opportunity to review that?
Yeah, Your Honor. Stay here, Judge.
Are there any additions or corrections?
Not from the state judge.
In addition to that, I have reviewed your jail incident reports. Everyone's been given a copy of those as well. Have y'all both had an opportunity to review those?
Yes, Judge.
I have, but I don't remember.
4 fights.
Yes.
Oh, yeah.
You like to fight, don't you? You don't? You don't? Okay. I can tell you that I have people in front of me all the time, and they're not doing what you're doing. Constantly fighting. And the way these reads, it does not necessarily show that you weren't the aggressor. It doesn't show either way on some of them, but it looks like these were some pretty mutual things going on, specifically finding places to fight, getting in the bathroom to fight so you can't be caught and all that kind of nonsense. How old are you?
Here's where things take a surprising turn. The judge doesn't just see a 19-year-old kid with car theft and evading charges. She sees a pattern of fighting, and not just random fights, but organized ones, staged in bathrooms to avoid being caught. That's not just immaturity, that's strategy. Instead of piling on more jail time though, the judge pivots. She pushes for ISF intensive sanction facility with a cognitive program designed to retrain decision-making. It's essentially a last-ditch boot camp for turning offenders around. Question is, will this defendant actually learn from it, or will he burn through his second chance like the last guy we saw?
19 years old. So here is where I am on this. I understand that you guys had agreed to the 180 days up front. I don't know that jail necessarily is as useful as potentially something like ISF cognitive track, because of its age, nature of the offenses, and what's going on in jail. The only way I'm going to go along with this agreement is to try to get you in a better place to make better decisions so that you can be successful on these probations. I want you to be successful. We all do. But at the rate you're going, you're not going to be. The conditions of your probation are always up to me. So I can give you what I want as a condition, anything that makes me feel like it would be helpful for you, helpful for the community. So what I'm going to do at this time is find that you previously entered your pleas of guilty freely and voluntarily. And cause number 24 DCCR 2440, find sufficient evidence to find you guilty, and at this time follow your agreement and find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with that agreement to a term of 10 years in prison, but probate that. You'll be on probation for 10 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. In cause number 25 DCCR 0209, find sufficient evidence to find you guilty, and at this time follow the agreement, find you guilty of unauthorized use of a vehicle, sentence you to 2 years in the state jail prison, but probate that. You'll be on probation for 5 years in that case. I don't have a fine. Is there no fine in that one? The 1,000 and the others probably.
There was just one fine.
It was just
Okay.
one fine in one case, Judge.
Okay. So in each of these cases, you're ordered to follow all of the rules and conditions of probation. One of those conditions is going to be that you enter and successfully complete the cognitive track of the ISF program. It's a 90-day program. It's in custody. You'll be transported from our jail to there fairly quickly. It's all about making better choices. Okay, so it's just to give you the tools you need so that you can be successful on this probation and not end up back in here and then going to prison. Do you understand?
This is where the stakes become crystal clear. Strickland avoids a straight prison sentence, but his freedom hangs by a thread. 10 years of probation means constant supervision, mandatory programs, and zero tolerance for slips. The judge even lays it out plain. One fight, one bad choice, and the deal collapses. Suddenly, that suspended 10-year prison term comes crashing down. It's a tightrope act. Walk carefully, and he rebuilds his life. Stumble once, and it's over. What would you do if you had 10 years hanging over your head like that? Would fear keep you in line, or would old habits creep back?
If you get in trouble now that you're on probation, if you get in trouble in the jail, get in a fight, if you get in trouble at ISF and you don't successfully complete it, you're going to already be in violation of your probation before you ever get out. So you need to figure out how to just stick to yourself, follow the rules, do what you're supposed to do so that you can get out and not go to prison, okay? All right, I'm handing you, and if you do everything you're supposed to, then for all practical purposes, your case here in court's over. You're going to serve those sentences while you're out on probation. But if you violate any condition of those probations, you'll be back in here and you'll be looking at the 10-year sentence and the 2-year sentence that you already agreed to. Do you understand? Okay, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Parker, okay? Good luck to you, sir. Take advantage of this opportunity. You can go back with the bailiff.
And there, you have it, 3 defendants, 3 very different outcomes. One man risks it all by rejecting a 45-year plea deal. Another loses his shot at bond after repeatedly breaking probation. And a 19-year-old gets a rare chance at redemption through a cognitive rehab program instead of hard time. These cases highlight the delicate balance judges face every day, protecting the public, upholding the law, and still trying to offer rehabilitation where possible. Some defendants gamble and lose, others get no second chances, and a few walk away with hope if they can hold on to it. If you found this courtroom breakdown as intense as I did, make sure to hit that like button, drop a comment with your thoughts, share this video with a friend, and subscribe for more jaw-dropping cases every week. Until next time, stay sharp, stay informed, and we'll see you in the next courtroom drama.